Be ready, start. The petitioner's grievance is that his bill of entry number 8048557 dated 28 September 2023 in bracket exhibit A bracket out is not being processed by the respondents by following the law. Mr. Shah submits that this is a case of re-imported goods regarding which the bill of entry was filed on 28 September 2023. He submitted that on account of the delay in processing this bill of entry, the shelf life of some of the re-imported goods, that is medicaments, has already expired. He submitted that the petitioner has prayed for a direction to the respondents to compensate the petitioner to the extent of rupees 80,435. The learned counsel for the respondents presented several difficulties before this court and expressed several difficulties by filing their affidavit in this court. At this stage, it is not for us to either discuss such difficulties or redress them. We take it that the respondents have ample statutory powers to deal with this type of situation. However, the only concern is that the respondents, by citing various difficulties, cannot simply refuse to process the bill of entry in accordance with the law. It is not for this court, at least at this stage, to direct the respondents to exercise their statutory powers in a particular manner. However, in a situation where nothing is being done to process the bill of entry, surely this court will have to step in. Accordingly, we direct the respondents to process the petitioner's bill of entry number 8048557 dated 28 September 2023 in bracket exhibit A bracket out as expeditiously as possible, and in any event within 4 weeks from today. Such a process has to be in accordance with law and on its own merits. The respondents should coordinate with each other for processing rather than blame each other for such non-processing. The prayer for an award of rupees 80,435 cannot be considered at this stage. However, the petitioner can adopt alternate remedies in this regard. All contentions of all parties in this regard are kept open. The petition is disposed of with the above directions to process the petitioner's bill of entry within 4 weeks from today and communicate the decision to the petitioner within this period. Accordingly, we set aside the impugned orders to the extent they deny the petitioner a refund. The respondents will now have to comply with the requirements of Rule 92 in bracket 3 and decide the matter afresh as expeditiously as possible. Mrs. Chauhan, learned additional government pleader for respondent, pointed out that the petitioner has filed undertakings not to press for refund of all the export periods except July 2022, August 2022, September 2022, and regarding the inverted duty structure for the periods from July 2022 to September 2022. The learned counsel for the petitioner has not disputed the furnished of undertakings but has submitted that such undertakings should not prevent the petitioner from seeking a refund. He submitted that the petitioner's representative was given a choice of furnishing the undertakings or otherwise foregoing the refunds even for the periods about which there was no dispute. At this stage, we cannot adjudicate upon the above controversy. Stop.